If you're handling a loved one's estate in Missouri and you're wondering if you need court permission to sell property, you're in the right place. Hi, my name is Deanne Schnurbush. I'm an estate and probate attorney out of St. Charles, Missouri. We serve clients in probate administration needs all across the state of Missouri. And today what we're doing is we're breaking down exactly when you need court approval to sell property of the estate and when you don't. So we start from the default presumption that for a personal representative administering an estate, you need court approval to sell that property. So like, let's say you have a piece of real estate or a car or some other valuable asset of the estate. In order to sell that property, you're going to need to file a petition with the court, notify interested heirs and parties, have a hearing in most cases, and get approval from the judge under the requirements of Missouri law in order to sell that piece of property. Now, generally, as part of that process, once you've gotten authority in Missouri, you're going to have to sell that property. When we're talking about real estate is the most common, you're going to have to sell it for at least 75% of the appraised value. In most cases, we're going to have to get an appraisal on that piece of real estate in order to get the property sale approved by the judge. Now, before the sale can close, you have to file what's called a report of sale with the judge. That basically says, here's the deal we got, here's the terms that we got it on, here's when it is closing and the percentage going to the realtor and all that stuff, okay? That starts a 10-day clock where anybody who may have an objection to the sale at that time gets the chance to voice that objection. And if nobody does, then at the end of that 10-day period, the judge will enter an order authorizing the representative to execute a deed on behalf of the estate, selling the property in exchange for presumably cash toward the estate. Now, the important thing to understand is that this is not always required. There are many different exceptions to this. The main one is if you're administering the estate independently or without court supervision. In order to get independent administration, you need one of two things. You either need to have a will that authorizes independent administration that has been properly and duly admitted to probate, or you need to have we call them renunciation consent forms from all of the heirs of the estate. And what that form says is that it's okay for the representative to serve in an independently administered capacity, that they don't need to get court orders to do everything. So that's going to be the most common exception to needing to get a court order. If you can get authorized for independent administration, you can sell that house or that piece of real estate without seeking any kind of court approval. The other area where you're not going to need to get court approval to sell is if the probate estate passes through some kind of short form procedure, such as a small estate affidavit, a refusal of letters application, or determination of heirship proceeding. Those are the most common ones. We talk about those in other videos. But if any of the short form probate proceedings apply, you don't need to get specific authority to sell the house. In those situations, the order that results from the small estate or determination or refusal letter application gets filed in the recorder of deeds office to show the transfer of title into the name of the heirs. And once it's in the name of the heirs, you can sell it whenever you want because it's your property now. It doesn't belong to the deceased person anymore. So again, in order to get authority where you need it, though, you're going to have to file that petition, notify interested parties, get an appraisal in most cases, get the court order, file the report of sale. And there's some common pitfalls that you're going to want to avoid. Do not sell that house without getting approval by the court or being told by your attorney that you're allowed to sell it without court approval. Don't mess up notice. You need to make sure that you're getting that, and your attorney needs to make sure that they're getting proper notice out to the parties involved in the probate case so that the order that the judge issues on the real estate sale or other property sale is actually valid and binding and not subject to being challenged at a later date. You want to make sure that you're not missing any deadlines. You want to make sure that you're filing that report of sale in a supervised sale situation at least 10 days prior to the closing date to give people the opportunity to object. And you don't want to be in a situation where you're contractually bound to sell a property, but you still don't have court authority to sell. In that case, the title company and the deal's gonna get you in hot water with your buyer. So that's another reason why it's a good idea from up front, if you're selling out of an estate, making sure that the buyer understands that we're dealing with probate, we're dealing with the court here, we've got a third party that we need to satisfy. So please be flexible with us on timelines. It's very important to work that out ahead of time as part of the deal. So Here's some practical tips when working with the sale of property. Make sure you're working with an experienced probate attorney so that these petitions to sell, if necessary, are getting filed early and often, so that we're getting them filed immediately so we don't have to wait. There's no delays in getting your authority to sell any property to the estate. Make sure that you're maintaining detailed records about the sale. Make sure that the cash is going into an estate bank account and that you're not putting it in your own bank account. Make sure the beneficiaries and heirs of the estate, that you're keeping them informed about what's going on with the sale. And that will most likely prevent any disputes or questions that you're going to get from other people. In many cases, you're also going to need professional appraisals, and you should work with a professional appraiser where necessary to make sure that you're getting numbers that you can rely on when making those sales. So that's, and just to recap all that very briefly, start from the default. If you're under supervised administration, you're going to need to get a court order before you can sell. If you're under any other kind of administration, either independently administering in a full probate or through a short form procedure like small estate affidavits, determination of heirship, and refusal letters, you're probably not going to need to get a court order. The other situation where you're not going to need to get a court order is if you have a will. If the deceased person had a valid will that was admitted to probate that authorizes even a supervised representative to sell, you can usually sell that piece of property without getting a specific court order. So those are some things to keep in mind when proceeding through probate in the state of Missouri. If you enjoyed this video, follow some of our other content, check out some of our other videos, and like and subscribe for the algorithm. Appreciate it, guys. Until next time.